I was engaged in the first time when the petition was filed. I personally didn't have my heart in it because I think that 370 is now a done deal. It's a fait accompli.
Yeah.
The more important question is really the dilution of the statehood to a UT and the abrogation or the trifurcation, etc., which is also, by the way, in a connected batch of petitions pending before the court. Number three, if you ask me as a professional, the issue on both sides is one, can a temporary provision, which is called a temporary provision, be abrogated by this legislation or by this procedure? Now, the heart of the argument, which is at the moment going on, and nobody's prejudging it, and it's for you and your viewers to judge it, is that the argument of the petitioners is that the moment the Constitution Assembly or the Constituent Assembly of Jammu and Kashmir, which as you know had one till the 50s, ceases to exist, 370 can be removed only by, I repeat the word, only by that Constituent Assembly. And if that Constituent Assembly has ceased to exist, then 370 itself becomes unamendable, unchangeable, permanent, indeed eternal. Now that's the contention. The argument of the other side is that the framers, the debates, the section itself, the article itself created it as a temporary thing. It cannot be that the vanishing of the Constituent Assembly of J&K will mean that 370 eternally will never be touchable. Now, that's the issue, the dilemma which the court has to grapple with. But as I said, my professional view is, again, please don't misunderstand me, I'm speaking purely abstract, without political part, without any political party.
Yeah.
The chances of any court in India holding that a provision like this is eternal and it cannot be changed now that 2 years have passed is obviously slim. The argument which I believe which has resonance is how much or can you reduce a state to a union territory in this manner?
I have a legal question though. In the context of a uniform civil code debate, in which you have said on our previous shows, show us a draft, you have the BJP's own allies in the Northeast, Nagaland, for example, come and say that this cannot apply to us. You have Sushil Modi, the head of the parliamentary panel, looking at this question saying, I agree. These are states that have a special status. Now, I have a legal question. If the abrogation of 370 is a done deal, can you in the same breath say, but no, there are other parts of the country that have a special status, which they do? Is that not a question that the bench will have to wrestle with? That if you say we want uniformity, we want one nation, one law, let's in whatever context, but you also say the application of 370 is a done deal. Kashmir can't have a special status. Okay,
Barkha,
why can the other states have a special status?
Yeah, Barkha, it's an interesting analogy you're drawing, but if you ask me professionally, conceptually, you are wrong.
Okay.
Why I'll tell you you're wrong. You can't draw the analogies because the question to be asked is legally, constitutionally, do you have the power to remove 370? The answer will depend on whether once the Constituent Assembly vanishes, you cannot do it ever. That question is not arising in the northeastern states at all. The question which would be analogous is if you first abrogated 371, ABCD, Nagaland, Meghalaya, etc., and the question was then raised that, look, you cannot abrogate 371. That's not the question. The question is, while 371 for Meghalaya and Nagaland stands, can you have a common civil code? The answer must be no. How can I impose a civil code on you while 371 stands?
Yeah, so but how can you say 370 should not stand, but 371 can? That's the question I'm asking.
Because that depends on the power. Tomorrow, if there is a political consensus, there is by a majority party, a political consensus. I'm not saying they're right at all. I'm not saying that they can do it by majority. Their political consensus is that we'll use our parliamentary power to abrogate 370. Yeah. They don't have the same political consensus to abrogate 371. If the question was raised that we want to abrogate 371, I don't see any power which can stop them. Tomorrow, if this majority government, the ruling government decide, I'm not saying they are right. I'm not saying I'm agreeing. I'm saying they said we have the brute power and we want to abrogate it. Which is the power which should stop them? If they get
Yeah.
two-thirds in parliament, they'll do it.
So basically, you're saying it's the political consensus that has led to the striking
Yes.
down of this article that was meant to be temporary in the first place. And all that the Supreme Court, you think, would likely focus on is whether, as the powers are allocated to the assembly, whether that procedure was followed.
Yeah.
Hypothetically, if we say, okay, that procedure wasn't followed, then what?
I personally and professionally, again, without any political party, without any other view, believe that court is highly unlikely to interfere. I
Yeah.
mean, that's the best I can say. I've not been presumptuous. I can't predict, but on probabilities, I'm saying this. Whereas the much greater resonance would be that you have suddenly reduced a large state into union territories. That would be an argument of greater strength and greater resonance. Again, whether that will succeed or not, I'm not saying.